Welcome everyone to the June Helen seminar. Today we'll be speaking about the legal and ethical significance of bioprediction for foreseeability, control and responsibility. Before I hand over to our speakers, I just want to begin by acknowledging the traditional owners of all of the unceded Aboriginal lands from which we are joining today. And in particular, I want to acknowledge the Wurundjeri Woi-wurrung people of the Kulin Nation, who are the traditional owners of the lands where Helen and the Melbourne Law School are located. Helen pays its respects to elders past and present and recognises the enduring importance of Indigenous knowledge in the Academy. So, two really great speakers for us today. First off, we're going to hear from Jamie Walvisch, who is a senior lecturer in the law school at the University of Western Australia. His research focuses on the intersection of criminal law and mental health, with a particular interest in how legal systems should respond to impaired agency in principled and non-stigmatising ways. He has published widely on sentencing, mental disorder, and criminal responsibility, and has worked with law reform bodies in Victoria, South Australia, and Western Australia. Jamie is also a legal member of the Western Australians Mental Health Tribunal and a board member of the Australian Academy for Forensic Scientists. And after Jamie speaks, we'll hear from Dr. Sinead Prince. Sinead is a postdoctoral researcher at the Centre for Biomedical Ethics within the Yon Lu Lin School of Medicine at the National University of Singapore. She received her PhD on the ethics of genetic enhancements in 2024 from the Australian Centre for Health Law Research and the Queensland University of Technology in Brisbane, Australia. She currently researches in AI ethics, genomics, and genetic technology ethics and reproductive ethics, with a common theme through these being the role, concept, and limits of autonomy. So, yeah, two wonderful speakers, and we're going to hear from Jamie first. So I will hand over to Jamie.
Thanks, Chris. So thanks very much for inviting me to speak today. And as Chris has noted, Sinead and I are going to be speaking about the legal and ethical significance of bioprediction. So I'm going to start by explaining where this work came from, and we'll then talk about the legal issues, and Sinead is going to focus on the ethical issues. And we'll each speak for around 20 minutes, hopefully leaving plenty of time for any questions. Before I get started, I just want to start by acknowledging that I'm working on the lands of the Whadjuk Noongar people and to pay my respects to their elders, past, present, and emerging. I also want to acknowledge that there were several people other than Sinead and myself who have been involved in this research. So we have worked together with Matthew Baum, Tasmia High, Julian Savalescu, Danielle Pacot, and Fergus Cameron. And we do have a forthcoming article together in Age of Neuroscience if anyone's interested in what we talk about today. All right, so our work in this area was prompted by the case of William Swale, which was a deeply tragic event that I imagine many of you will be familiar with. So Mr. Swale was a 69-year-old man who in November 2023 drove into a crowd outside the Royal Daylesford Hotel in Victoria, killing 5 people and injuring several others. Now, he had lived with type 1 diabetes for decades. He used an insulin pump and a continuous glucose monitor, which I'll call a CGM, which is a device that's worn on the body that continuously checks glucose levels and can alert the person when their levels are becoming unsafe. And by all accounts, Mr. Swale had been very diligent in managing his condition for years. On the afternoon of the incident, at around 4 p.m, he checked his blood glucose and it was comfortably within his target range, so he administered his insulin as normal, expecting that he was going to eat soon after. But then his plans changed and he instead decided to drive off to Daylesford, which was about 40 kilometres away. By around 5:15, his CGM recorded a sharp drop to a level that was well below the safe threshold for driving, and it began generating low glucose alerts. So he stopped at a cafe near the centre of town, apparently intending to get something to eat. But unfortunately, the cafe was full and he was turned away without any food. Now, what happened next isn't entirely clear, but what we do know is that about 20 minutes later, CCTV footage shows his car moving slowly through the streets of Daylesford, at times stopping in the middle of the road. And then moments later, he suddenly accelerated through a roundabout and into the outdoor dining area of the hotel. And witnesses described no signs of any braking or swerving. And emergency services found him slumped in the driver's seat, sweating and unresponsive, and his blood glucose level was extremely low. So they treated him and he regained consciousness, but was extremely confused, repeatedly asking, where am I? Where am I? Two endocrinologists gave evidence that at the time of the crash, he was in a state of severe hypoglycaemia, incapable of deliberate thought or voluntary control. But he was charged anyway with several offences, including 5 counts of culpable driving causing death. But at his committal hearing, the magistrate found that the prosecution couldn't prove that his actions at the time of the crash were voluntary, and so dismissed all charges against him. Now, unfortunately, the Daylesford crash isn't unique. There have been several similar cases around the world. But interestingly, they haven't all ended with the same legal outcome. So some have ended like the Daylesford case did, with a finding that the driver's actions weren't voluntary. So, for example, in New South Wales, Brendan Lidgard, who was a long-distance truck driver with type 1 diabetes, had a sudden hypoglycemic collapse and killed a young girl. And like William Swale, he was acquitted. By contrast, though, Alan Mackey in Canada and Thomas Treadwell in the UK were both convicted of dangerous driving causing death after fatal crashes associated with low blood glucose. Now, that contrast, where you have a similar medical reality that produces different legal outcomes, was one of the things that prompted our work, because colleagues outside the law were understandably puzzled. They wanted to know, look, how can this same loss of consciousness from hypoglycemia excuse in one case and convict in another? Is this simply a jurisdictional difference with Australian courts taking a different approach from UK or Canadian courts, or is something different going on here? But the Daylesford case also raised an interesting question for me, even though I understood legally what was going on here. I wanted to know whether technologies like CGMs or other technologies that go even further and don't just monitor current glucose levels, but predict future changes, could change the legal landscape in this area. And I know my interest here isn't limited to diabetes. There are biopredictive technologies in many other areas that use physiological data together with algorithms or AI to predict a person's future physiological or cognitive state. So, for example, they might be able to predict the likelihood of a future epileptic seizure or the relapse of some kind of a psychiatric illness. So what interested me was this question. If a technology is available that can warn a person before they become impaired at a time when they still understand the risk and are able to act on it, can that change the way we go about assessing criminal responsibility? But let's start with the first question, because I imagine not all of you are lawyers here, which is understanding why some of the hypoglycemia cases have led to conviction and others to acquittal. And to understand those different outcomes, we have to start with the basic principles that underpin criminal responsibility. So most legal systems share a common foundation. A person can only be found guilty of a crime if they performed a voluntary act, an act done consciously and under their own control. So if a person enters a hypoglycemic state that's so severe that they become unconscious or act automatically, steering, accelerating, braking without any awareness, then legally their body might be moving, but their mind isn't directing it. And in those circumstances, it's generally regarded as unfair to convict them. So in criminal law, this is often called automatism, and complex distinctions are sometimes drawn between what the law calls sane and insane automatism. And whether a medical episode is classified as one or the other can matter pretty significantly for what follows, for example, whether the person is subject to court supervision. But that's not my concern here. That's obviously important in its own right, but not what I want to focus on here today. For present purposes, the key point is simply, if the conduct was not voluntary at the time of the crash, the person will generally not be held criminally responsible. But there is an important exception. In limited circumstances, a person can be held criminally responsible for involuntary conduct if they were to blame for getting into that involuntary state. So this is what's known as the doctrine of prior fault. And perhaps the clearest example here is a person who drinks heavily, knowing that that might seriously affect their awareness and control, and then they get in the car and drive. So if they then later black out and injure somebody, the law can point to their earlier decision, the decision to drink and then put themselves in a position where they posed a foreseeable risk to others, to attribute responsibility to them. So in such cases, it may not matter that they were acting involuntarily at the time of the crash. They can be held criminally responsible because of their earlier conduct. And this same principle applies in the diabetes driving context, meaning that the mere fact that the person was hypoglycemic at the time of the crash isn't conclusive. Instead, the court can look at the driver's conduct before they became hypoglycemic, asking questions like, did they have any indication that their blood glucose was dropping and continue to drive regardless? Or was the onset, truly sudden and unforeseeable? And this is why cases like Mackey and Lidgard had different outcomes. In Mackey, the driver continued to drive despite knowing that his glucose was falling. So his decision to remain on the road was treated as reckless and sufficient to ground criminal responsibility. By contrast, in Lidgard, the hypoglycemic event was sudden and without warning. So with no opportunity for foresight or prevention, there was no prior fault to speak of and no basis on which he could be held responsible. There's one final piece of the legal framework that I have to mention here, which is the requirement that the physical act and the mental state required for the charged offence occur at the same time. And lawyers sometimes call this the principle of contemporaneity or the coincidence principle. The guilty act and the guilty mind must coincide. And the Dalesford case illustrates the problem that this can create in these cases. So in that case, Mr. Swale was charged with culpable driving causing death, a charge that requires proof that he drove in a manner that was reckless or grossly negligent, and death resulted. So to prove that charge, you have to focus on his driving conduct. And if you think about it, there were actually two different driving episodes in this case, when he drove to the cafe and when he drove from the cafe. When he started his first driving episode, everything was fine. But at some point during that drive, his CGM began generating low glucose alerts. Now, if he'd ignored those and continued driving, the legal outcome might have been different. But he responded. He stopped at a cafe intending to eat, so there was no culpable driving act in that first episode. Now, I mentioned before that we don't know what happened in the 20 minutes after he left the car, before he started driving again. And one consequence of this is that it was entirely possible that when he got back into his car the second time to drive, that he was already experiencing severe hypoglycemia. So that entire second episode of driving might have been involuntary. So even though his driving was culpable during that episode, it couldn't be shown that he was acting recklessly or negligently because he could have been entirely involuntary. Now, you might be wondering why he couldn't be held criminally responsible for failing to eat before getting back into the car. Surely he could have found something to eat, even if the cafe didn't serve him. And in fact, recent evidence in the current coronial inquest that's happening into this case at the moment has suggested that there was food in his car. So wouldn't that perhaps be enough to make him criminally responsible? But the problem here is that when he chose not to eat, he wasn't driving. And the culpable driving charges brought against him require proof of a culpable driving act. So this is the heart of the coincidence problem. At the cafe, or during the missing 20-minute period, he may have been acting voluntarily, but there's no culpable driving act. By contrast, during the second driving episode, there's a culpable driving act, but it's possible that by that time he was acting involuntarily. So the two components for criminal liability never aligned. In Mackey and Treadwell, by contrast, the drivers remained aware of falling glucose levels while they continued driving, so the mental state and the physical act coincided. So this brings me to my second question, which is whether modern medical technologies like CGMs or predictive glucose systems and closed-loop insulin delivery systems can change the legal landscape at all. And let me start here by talking about CGMs. So the most immediate way that CGM technology changes the legal picture is a practical one. It creates a record. Before CGMs, courts in these cases had to piece things together from medical evidence, witness accounts, driving behaviour, the person's recollection, and often the legal outcome would come down to whose account is believed about who knew what at what point in time. But a CGM can change that. It records glucose levels in near real time, whether levels were rising or falling, when alerts were generated, and whether those alerts were acknowledged. And that can give contemporaneous, objective evidence of a kind that hasn't previously been available. It can give a court a much clearer picture of what the situation was and what information was available before the person lost control. And this was one of the really interesting things in the Swale case, where the prosecution relied very heavily on CGM data to reconstruct the timeline of the falling glucose and the alerts. But interestingly, that data couldn't prove that Mr. Swale actually perceived and understood those alerts at the relevant time. And that matters because the legal question here isn't just whether the data existed, but whether it gave him a meaningful opportunity to understand the risk and to act on it. And the problem here is that hypoglycaemia can erode a person's ability to process information gradually in ways that might not be obvious even to the person themselves. And in this case, the magistrate just wasn't persuaded that the prosecution could prove that he knew what was going on when he resumed driving, despite all of this data that was available. Now, one interesting question that can arise here is what happens when a person actively ignores or disables the alerts that they're receiving. And this happens a lot due to what's called alarm fatigue. And this occurs when a device alerts users so frequently that they just start dismissing notifications without really paying them any attention, or they switch them off to get through the day without being constantly interrupted. And while that's understandable from a daily management perspective, I'm sure we've all been annoyed by alerts coming from our various devices. From a legal perspective, if a crash later occurs, it does make it hard to say that the risk was unforeseeable. But that said, there might be a difference between someone who has made a deliberate and considered decision to disable alerts and someone who has gradually stopped attending to them through the kind of sheer exhaustion with an overly intrusive system. And in the future, courts might need to grapple with where on the spectrum a particular person sits. And the opposite problem can also arise here, I should say, over-reliance on devices. Some users might come to depend really heavily on CGM alerts, so much so that they stop attending to their physical symptoms. And if they drive trusting a device that then turns out to be faulty, the question becomes, well, was the failure theirs or the technology's? And the legal outcome here is likely to depend on several factors, such as what symptoms they were experiencing and whether they had any reason to anticipate a potential malfunction. Now, this analysis shifts more fundamentally when we move from monitoring to prediction. So a CGM tells you what your glucose level is now, but some newer systems go further. They use real-time physiological data together with machine learning to forecast what is likely to happen in the near future. So, for example, they might be able to warn a person that if they don't do anything about it, they're likely to have a hypoglycemic episode in 2 hours' time. That temporal shift can be legally significant because the logic of prior fault depends on identifying an earlier point at which a person had both awareness and control, yet failed to act. So a monitoring device like a CGM may warn only once the risk is already materialising. And as the Daylesford case illustrates, that might be too late to create a meaningful opportunity for intervention. A predictive system, by contrast, creates a genuine window of time between warning and incapacity, during which the person might still understand the risk, retain control, and have real options available to them. And that window could alter the legal outcome. I do want to be careful, though, not to overstate this. The mere use of a biopredictive technology is not necessarily going to lead to a different legal outcome. And this is because systems vary considerably in their accuracy, their reliability, and the clarity of what they convey to users. So, a vague or a low confidence alert isn't the same as a specific, reliable warning. A system that's prone to frequent false positives will, over time, erode a user's confidence in that system. And the law, I think, should be slow to treat a dismissed alert from that kind of a system as a straightforward indication of prior fault. For a predictive warning to ground legal responsibility, it really needs to be reliable enough to take seriously, comprehensible to the user, and timely enough to permit a proportionate response. The law shouldn't treat the mere presence of technology as conclusive. What matters in each case is whether this warning from this system at this moment gave this person a genuine opportunity to act. Now, automated systems complicate this analysis even further. So here we're talking about something like a closed-loop insulin delivery system, which can combine continuous monitoring with automated insulin adjustment, modulating delivery in real time as glucose levels change. And the most advanced systems now do this with very minimal user input. And that can reduce the burden on the person, but it's not necessarily going to eliminate responsibility. What it does is potentially redistribute it. So the user might still need to set up and maintain the device, respond to system prompts, and avoid relying on a system if they know it's malfunctioning. So if they disable the alerts, if they neglect their maintenance, or they persist to use a device that they know isn't working properly, those earlier choices may still be traced back to them and they may be held responsible. But if a person reasonably relies on a validated system that appears to be functioning properly, and harm arises from a failure that they had no reason to anticipate, the analysis changes. There, the user's responsibility might be reduced, and it might even shift towards the manufacturers of the system, to software developers, to clinicians, to regulators. So in other words, these technologies could start to change where accountability sits in the system. To finish up, let me just quickly draw my part of the presentation together before handing over to Sinead. So the starting point is simple. A person generally shouldn't be held criminally responsible for conduct that wasn't voluntary. But prior fault already allows the law to look backwards and ask whether there was an earlier opportunity to foresee and prevent the loss of control. CGM technology changes that analysis by turning what used to be a subjective reconstruction into an objective record. Predictive technologies change it further by creating a genuine temporal gap between warning and incapacity, a window during which the person may still understand the risk, retain control, and have real options available to them. And automated systems complicate the picture by distributing control between the person and device, which in turn may distribute accountability more broadly. But none of this means that people who use or who have access to biopredictive technologies should always be held responsible for the consequences of involuntary conduct. The legal point here is much more limited. These technologies may create an earlier point at which responsibility becomes legally possible, a moment before incapacity, when the person may still understand the risk and may still be able to act. But that only takes us so far. The harder question here, I think, is whether it's fair to impose responsibility at that earlier point. When can we actually reasonably expect someone to respond to warnings, or to maintain a device, or to acquire predictive technology in the first place, so that if they fail to do so, they can be held criminally responsible. And what responsibility should the state bear if these technologies are expensive or difficult to access, but can help reduce risk? These are the kinds of questions that Sinead is going to focus on in her part of the presentation, and I will now stop talking and hand over to her. Thank you all very much.
That was great, Jamie. My name is Sinead. I'm a postdoc at the Centre for Biomedical Ethics here in Singapore, in sunny, warm Singapore. I hear the weather has taken a turn back home. And I have the delightful responsibility of having to follow the most eloquent public speaker I know back to back. So Jamie, as always, amazing. Thank you for setting the scene so eloquently. So the question that I've been tasked with is, even if responsibility becomes legally possible, when is it fair to impose it? So largely the philosophical literature on moral responsibility fairly well tracks the law. So we have two conditions that are most widely discussed. We have the epistemic condition and we have the control condition. So the epistemic condition is what the person must know. Most people agree that in order to be morally responsible for an act or a conduct or some harm, you actually have to know what you are doing. You have to be physically aware of the reality of what's going on. Now, there is some disagreement about whether or not the person needs to know whether what they're doing is right or wrong. And fortunately, due to current driving regulations in Australia, most people ought to know by their doctors that they need to test before they drive. They need to, if it's under 5 to drive, if the person's blood glucose is under 5 mmol per litre, then they need to take some fast-acting carbohydrates and then wait 30 to 45 minutes before driving. So most people actually know this, or ought to know. It's their doctor's responsibility to inform them. And the third thing that a person must know in order to be held morally responsible is that the consequences of their decision are reasonably foreseeable. Most of us, just by virtue of being humans, pose risks to others when we drive. There is always the risk that someone might have an unpredictable stroke. There is always the risk that something just might happen whilst driving, and we might pose a harm to others. But we don't expect all people to abide by all risks, no matter how small. The consequences have to be somewhat objectively reasonably foreseeable. Now, we also have the control condition. And so the control condition fairly well tracks the law as well. It talks about how the person must take the action voluntarily. And there are two ways to look at this. The first is that the person needs to have control over their actions. And some people say that what we're actually looking for is an alternative, which is the ability to do otherwise. And so this brings us to cases like Swale. How does the epistemic condition in philosophy around moral responsibility apply to people who were unaware of what they were doing at the time they were doing it? And so again, as well as the doctrine of prior fault, we have a similar area of literature. We have exculpatory ignorance and we have culpable ignorance. So exculpatory ignorance is the idea that you were ignorant at the time of the act that caused harm, and there was no way you could have avoided it. There was no way you could have known that it was going to happen. So the most obvious example of this is an unpredictable stroke whilst driving. It just happened. There was no foresight, there was no risk, or there was no above tiny minuscule risk. It was completely unpredictable. And so for these cases, it's very obvious to say, not morally blameworthy. How could you have known to do otherwise? However, culpable ignorance is a thing. It talks about benighting acts. So there was an opportunity, an earlier window where you could have known, you could have learnt of your risk, or you knew of the risk, and yet you failed to do something about it to prevent it arising. So these are called benighting acts. Now, there's a lot of controversy around the standards, the thresholds, at what point an earlier decision becomes a benighting one. But we can also talk about we can get a really good case example of this in drink driving, which is the person knew exactly what they were doing up until the moment they got in the car, and they had alternatives to do otherwise. It's a culpable ignorance. And these are generally considered to be blameworthy. And so out of these two things, to know whether ignorance is exculpatory or culpable, we have sort of two conditions that we need to look for. One is that the negative outcome was reasonably foreseeable. And two, the more controversial one is the person is responsible for their own ignorance of the relevant moral information. They should have known, or they could have easily discovered the potential consequences. And so this is where it starts to get a bit tricky. So applying this to blood glucose level management, we have a fair amount of research that suggests that there are drivers who have diabetes, who are using blood glucose level management tools, and who have previously had a driver's mishap relating to hypoglycemia or blood glucose levels issues, is that they are actually less likely to test their blood glucose levels before driving. We also know that many people fail to take that 30 to 45-minute normalization period after having tested, noticed that their blood glucose levels were too low to drive, and they have failed to eat. They've failed to wait 30 to 45 minutes after having taken some fast-acting carbohydrates. And that's concerning because we also know that it takes 40 to 45 minutes for cognitive capacities to generally, on average, restore after having eaten. We also know that people actually don't even stop when they have perceived that their blood glucose levels have fallen. Now, these studies are naturally limited. They're a bit older and they are based on simulations where people are not actually driving. So we need to be careful about how much we rely on some of this evidence. But we do know that it is that these three things do in fact happen. And so we can see here, if we look very common sense, very intuitively, that in that case of when people fail to test, we would say that this might be culpable ignorance. You were told and informed and required by regulation to test. You had to test to learn that what your blood glucose levels were. And then with the other two, we might call these actual awareness. So the person had tested, taken those carbohydrates and failed to eat. The problem wasn't an epistemic condition, it was a control condition. And the same with that third one. They had actually perceived that their blood glucose levels had fallen, and so they were actually aware of the risk that they were posing on the road. The problem, as Jamie so eloquently pointed out, is that we have currently with our technology, the limits of capacity place a dark shade over our ability to prove these things actually happened. And so we run into a really difficult problem, which is that people who are not hypoglycemic or not close to those blood glucose levels falling to a level in which cognitive capacities decline and don't test generally aren't going to go on to cause harm for or relating to blood glucose levels. So they made a bad decision. They should have checked, but they didn't go on to cause harm. And so there is moral responsibility, but no blameworthiness because no harm arose. But then we have the opposite situation where people who are hypoglycemic or are very quickly about to be, and they're the ones that don't test, we can't actually prove responsibility because, as Jamie pointed out, we don't have that alignment. And so even if they go on to cause harm, we're generally not quite equipped with the technology to hold them morally responsible. Now, with the introduction of biopredictive technologies, our capacity to look at this epistemic condition has shifted. So we can see that when people fail to check, that it's a reasonably foreseeable consequence that in failing to check, that their blood glucose levels might be unsafe and that they may go on to cause harm. However, we have deeply unclear responsibility for ignorance. We do not have the technology or the third-party capacity to always prove moral responsibility, that they had the capacity at that time and that epistemic condition was fulfilled. So that's that paradox that I pointed out, that they are unlikely to be morally responsible for harm, although they still made a bad choice. And so even if they fail to respond to a real-time alert, we might say, excellent, we have a point there that they had been informed, but we again have unclear responsibility for ignorance. We cannot and do not have the technology to prove they had the capacity to be held morally accountable or morally responsible. However, predictive alerts change this. So particularly when we're talking about those biopredictive technologies that alert, that have around 98% accuracy when they give an alert around 4 hours in advance. when we're talking about these sorts of biopredictive technologies, it is reasonably foreseeable that failing to respond to a predictive alert, that blood glucose levels will drop below legal requirements, and that we start to have a much higher threshold of proof that they had capacity to be aware of that risk. And so this is where it starts to get quite interesting. So we have likely to be morally responsible for harm, as well as in situations where people are using those closed loop systems. So these are the systems where you pair a predictive CGM with an insulin pump and they feed the data between each other. Now, these are getting even more high tech. So I've seen some recent research which indicates that people no longer even have to manually input data, such as what they ate or if they've done exercise, and that these technologies are getting so good at reading personal data histories that they can essentially manage everything within that closed loop system. And so if someone failed to maintain, such as failing to update a technology, failed to respond to an alert that the system had failed to calibrate, or in other ways failed to actually use the system in accordance with reasonable expectation, that again, these sorts of people are likely to be morally responsible for harm that follows if they fail to deal with that and then go on to lose capacity whilst driving. And so biopredictive technologies can change the point at time at which these conditions can be assessed. And so for those who are already using these technologies, it may be likely to be fair to impose responsibility for those harms. But again, that always comes back to those conditions that Jamie talked about, which is that technology reliable? Has it been validated? Is it up to date? All those sorts of things. Is it giving 4 hours in advance, or is it just giving 20 minutes in advance? But I think the more interesting question is, what about people who don't yet use them? And so the literature on moral responsibility starts to diverge much more in these sorts of cases. So we seem to expect people in life to learn about certain risks that they may pose, and even potentially expect them to bear some costs to learn that information. But where do we draw those lines can be quite tricky. So the question becomes, do all people with diabetes or who rely on insulin for blood glucose level management have moral obligations to acquire these biopredictive technologies so that they could become aware of the exact risk that they pose to others whilst driving? And so this sort of introduces the limits of the epistemic condition. And there are so many factors that have been raised. There are factors like the seriousness and likelihood of the risk that we pose. If a biopredictive technology came out that indicated every single person's possible risk of a stroke, would we expect anyone with a license to go out and buy them no matter how much they cost? So then we also have questions about reliability of technology, the burdens of precautions, so how costly and expensive the technologies are. If that test is free, we would say, of course, everyone should go test. But most of them are not. Most of them are quite expensive. We also have questions around, do these technologies actually give people sufficient time to respond? Is it a 20-minute warning? Because if so, maybe that's not enough. Hypoglycaemia can come in within minutes if that blood glucose levels just drops. Then we also have questions around access to technology. Are there legitimate alternative options that are less costly, even if they are less efficient or accurate? And then we also have extenuating circumstances for individual people. And so this brings into questions around what costs are we obligated to bear in order to prevent our personal risks of harm arising to others. So we can see that manual injections and blood prick tests are the basic way of managing blood glucose levels. These are not by any means cheap, but they seem to be on the lower end of the costly spectrum of blood glucose level management technologies. And in places like Australia, a lot of these are heavily subsidized as well. Insulin pumps are much more expensive. $8,000 to $12,000 a year is quite an exorbitant cost for that kind for a piece of technology. CGM devices are also fairly costly. I do know that in Australia, these are also heavily subsidized for people with type 1 diabetes, although the conditions to access naturally vary. And then we have AI enhanced systems and predictive systems. So these are around $2,000 to $4,000 a year, which if it's starting to add up, none of this is going to be fairly affordable for many people. And then closed loop systems, an exorbitant $10,000 to $20,000. That's just out of the question for many, if not most people. And so what we need to ask is, who is obliged to pay what costs? Now, Matt Baum, one of our co-authors, has developed a really excellent risk banding model when it comes to bioprediction. So we know that in Australia, or not in Australia, sorry, in general, 20% of people with diabetes cause 80% of the incidents pertaining to driving-related mishaps arising from hypoglycemia. So this is a small group of people who represent the highest risk. And we're actually getting much better at screening and identifying these people in advance. So we know that it's persons with type 1 diabetes have significantly higher risks of driving mishaps in comparison to those with both type 2 as well as their partners without diabetes. We also know that history matters. So having had a driving mishap creates and contributes to that high risk. We also know that having experienced severe hypoglycemia increases that risk. We also know that those without self-awareness of their own personal risks or symptoms of hypoglycemia have a much higher risk of going on to cause an accident later. Now, these are things that we already screen for in the clinical room. But just to put this in perspective, I know this data is a little old. I haven't been able to find anything more recent. But in 2006, only 0.4 to 3% of all driving-related accidents could be attributed not just to people with diabetes and hypoglycemia. This is all medical conditions, so including those undergoing chemotherapy, those under or experiencing epilepsy. All medical conditions only account for less than 3% of driving-related mishaps. So we are talking about a very small number of people when we're talking about people with diabetes and the risks that they may pose due to hypoglycemia. And so coming back to those conditions of feasibility, when we talk about who is expected to bear the burdens of addressing those risks, we can see that one of those conditions is proportionality of risk. And so all people with diabetes do not pose equal levels of seriousness of risk. So we have those who only pose a possible risk, that just by virtue of being diagnosed with diabetes, there is a possibility that they may experience hypoglycemia whilst driving. In the same way that anyone who is a human have possible risk of having an unpredictable stroke whilst driving. Their risk is slightly higher than the average person, but it's only possible. Whereas using those screening technologies and screening mechanisms in the clinical room, we can actually identify those who pose a higher than possible. In fact, it may even be a probable risk of harm. And so we need to start to use our technologies to differentiate these groups, particularly when it comes to medical regulation around driving. The second is proportionality of costs. Not all people have equal access to these technologies, and not all people can equally forego a driver's license across the board. So for some people, the financial costs are itself a barrier. They would just have to, if they were expected to acquire these biopredictive technologies in order to drive, they would just simply have to forego driving altogether. That is a significant barrier to place onto someone. However, that's not the same for those who live in areas with really great public and affordable transport in comparison to those who live in remote and regional areas. And interestingly, those in remote and regional areas already may pose a lower risk simply because there are fewer people on the roads. And so requiring someone to either pay $4,000 or give up their driver's license if they live out in a remote area, we're actually asking them to give up their life. We're asking them to give up their work. We're asking them to essentially stay home and not have equal participation in society. And that's just not fair. And so what we argue in the paper is that for probable risk individuals, to be honest, they're higher risk of higher harm, as we saw in the Swale case, that tragic level of harm. Those costs just do not defeat the moral obligations to prevent that kind of harm. However, for possible risk individuals, practical concerns are probably going to defeat those obligations. Some people have pointed out that actually these technologies pose a benefit. They're actually cost effective in the long run by reducing hospitalization and lifetime risk of major comorbidities and complications. But upfront cost effectiveness is not the same as long-term cost effectiveness. And so I'm not convinced that we can rely on arguments around it's better for someone to undertake these technologies as is to prevent harm to others. However, we don't think that the story ends there. I don't think we can just point to people and say, no matter what the cost, you need to buy these biopredictive technologies or stop driving. There is some really helpful literature out there on what states owe as a matter of justice to people with medical conditions. And so, drawing on John Rawls's difference principle, where he talks around if we cannot equally distribute goods in society, then we should be distributing goods to benefit the worst off. And the way that Norman Daniels has done I think, a really great job of trying to apply that principle to healthcare in his work, Just Healthcare, where he talks about how equal opportunity to participate in society requires fair healthcare distribution. And so I think that there is actually a morally equivalent argument to be made around driving. For some people, participating in that minimally decent life that we are all owed as a matter of justice under that principle of equal opportunity, driving may be equivalently essential. And if that is the case for people, then states have a meta obligation to help people gain control, the necessary control to discharge their obligations. So I think what this means is that if states are going to start to impose obligations on individuals to pay these costs or to use these technologies in order to be considered fit to drive or licensed to drive, then they have corresponding duties to subsidize these costs as well. You cannot have one without the other. And so essentially our argument is that governments have moral duties to develop and subsidize these technologies so that people can discharge their obligations that arise from experiencing medical conditions. And I also think that the way we go about this will matter deeply. We know that people with diabetes already experience discrimination in society. We know that they actually do not pose the largest group of driving risks. Anyone who has ever driven at night or in the rain poses a higher risk, as do all young men and many elderly people. And so we need to be extremely careful about how we go about imposing quite exorbitant or costly obligations on people whose risks are not equivalent to the majority of people on the road. And so we think that what this means is that the use of biopredictive technologies may actually allow us to remove obligations and restrictions on many people with diabetes because they do not fall into that high-risk group. We also know that many people with diabetes face a lot of stigma and shame around that medical condition. We also know from research that having to just go and get a medical certificate can make them feel begrudged. They know that there are other groups out there, like young men, who pose much higher risks than them, but are not forced through the same experiences and the same restrictions. So again, we think that biopredictive technologies could actually reduce the need for a lot of people to have to get certified as fit to drive or licensed to drive. And any way that we go about rolling out these regulations and policies needs to be very clear that we are distinguishing blameworthy actions, such as failing to properly maintain technology, from having diabetes in the first place. And so looking forward, we need to start looking around, governments need to start dealing with around distinguishing unconditional and conditional licensing, whether that's fit for our modern era anymore. We need to talk about how this will apply to minors with diabetes who are seeking provisional licenses. We also need to start to talk about, is this going to be a matter for legislation and statute, or should we be leaving this to the courtrooms to deal on an ad hoc basis? Should this be a criminal or civil matter, and should it be entirely exculpatory, or should it be exemptive when people go on to fail to use these biopredictive technologies fairly? Essentially, our overarching argument is that the aim should not simply be to expend and expend blame, but to develop fairer forms of risk governance. And that's exactly what biopredictive technologies are going to allow us to do in the future. Thank you.
Wonderful. Thank you both. Thank you, Sinead. Thank you, Jamie. Absolutely fascinating area. So look, I want to thank you both for a really wonderful talk, really interesting area and really well spoken. Sinead's actually going to be leaving her sunny Singapore and visiting drizzly Melbourne in late July, and we'll be doing another talk on genetic enhancement then. So watch out for your emails for news about that. And yeah, I will thank you both again and wish everyone a lovely afternoon. Goodbye.